I'm Joe McDaniel, and I'm an Arizona bankruptcy attorney. And since 2005, I get to tell you that I'm a debt relief agency, and I help people and businesses file for bankruptcy, as I have for about 30 years. Today's musical bankruptcy question is, but don't I have an absolute right to convert my bankruptcy case to a Chapter 7 or a Chapter 13? Well, no. For a long time, from October of 1979 to 2007, some rights in a Chapter 13 case were considered absolute. Why would that be? Well, partly because the statute seemed to say they were absolute. For instance, 11 U.S.C. Section 1307 talks about what is described in the legislative history as a, quote, absolute right, end quote, to convert. Note that 11 U.S.C. Section 707 also talks about a seemingly unfettered right to convert in the other direction. But in 2007, the Supreme Court of the United States decided that absolute meant absolute if I say so, which means a little less than absolute to me. The case was Marama, located at 127 Supreme Court 1105, 2007. Of course, even if Marama had not come into existence, the right to convert would mean far less under the 2005 amendments. And that's because a Chapter 13 is far less desirable than a Chapter 7, because the carrot that previously seduced people into filing Chapter 13 was the super discharge, which is a thing of the past. And the Chapter 13 plans now run longer in cases where the means test isn't met. Under the super discharge, a debtor who had civil liability for embezzlement amounts, for instance, could discharge that liability in a Chapter 13. I know that, partly because one of my previous clients did exactly that. I think the poor guy had a gambling problem. But that was many, many years ago. These days, barriers to conversion include the fact that a debtor may not qualify for a Chapter 7 under the dreaded means test, which means that a right to convert to a Chapter 13, a Chapter 7 is no value to him. And the barriers work in the other direction. A right to convert from a Chapter 7 to a Chapter 13 is worthless if the debtor has more debt than the time adjusted debt limits under 11 U.S.C. Section 109. Thank you.